Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
William, you lying sack of shit. You know I didn't block you to begin with. I was just asking about you because I may indeed be willing to sell you the elephant diamond art. I am sure you heard that and that's why you're here. I'm sorry I'm a bit late, guys. I literally feel like, I am working what I would consider a triple shift today. And this is about to be my first sip of coffee. I love you, coffee. But I'm almost out of coffee. It's so terrible. It's a terrible, terrible sin. Oh, it's hot. I love it when it burns me from the inside. Anyways, this is our show for today, by the way, because I won't be home till like 10:30 tonight. But do I have a doozy for us in the next couple days, which is why we have to finish up this quickly because I'm still recording it. Yeah. So, let us get going. We have Judge Bronlick. He's in such a fucking pissy mood every time. You know how yesterday Judge Kirkham was like sort of happy? Judge Bronlick not happy ever.
For the record, this matter is before the court to review defendant mother's parenting time. The hearing is being conducted via Zoom. Present is Attorney Eugene Ferguson representing the plaintiff father, Cody DeFalco. Mr. DeFalco appears to be present with Mr. Ferguson. In addition, Attorney Christopher Fleming is present representing the defendant mother, Lauren DeMille, and Mr. DeMille appears to be present with Mr. Fleming. Good morning, everyone.
Morning.
Good morning, Judge.
Good morning, Your Honor.
The last order of this court entered in October, provided for supervised parenting time for defendant mother with family counseling shelter services. The parties have conferred with Mr. Walker from the front of the court this morning. Mr. Walker is recommending that mother have specific unsupervised parenting time as follows. Every other Saturday from 10 a.m. to 3 p.m. The mother shall provide proof that she's attending AA meetings to father or his counsel every 30 days. Neither party shall consume alcohol or any non-prescription drugs immediately before or during parenting time. And anyone that transports a minor child must have a valid driver's license. Finally, the parties will appear back for court to review mother's parenting time on February 5, 2025 at 10 a.m. via Zoom. That is the recommendation. Mr. Ferguson, is this recommendation agree with your client this morning?
No, we object to the recommendation.
Okay. I'll talk to Mr. Fleming. Mr. Fleming, is this recommendation good with your client?
My client would accept it at this time, Judge.
My client Paisley accepts Shane as a new member. Woo! Yay, Shane! We did members only yesterday. Out of pocket. That's not what that means.
All right, Mr. Ferguson, the basis for your objection, I guess, first of all, the question the court has mother been regular exercising your supervised parenting time with family counseling shelter services?
She has, Judge. She's attended, I believe, about approximately 7 sessions at this time. There has been reports from that generated. I believe I sent them over yesterday to your secretary, Judge.
Not seen them. Not
Okay.
seen Mr. Fleming.
All right. But in essence, Judge, and Mr. Ferguson agreed that all of the sessions have been going well. There have been no issues whatsoever with the sessions, and they've been going excellent.
All right. And Mr. Ferguson, presumably Mr. Walker makes his recommendation having reviewed all the reports from the supervisor at Family Counseling Shelter Services. So what is your client's objection to unsupervised for, it's like, what, 4 hours, 5 hours, on alternate Saturdays?
My objection is this. From the beginning of this case, the defendant had supervised parenting time. She's never had unsupervised. We filed 2 motions because of her very poor behavior. The first time we filed it because she was vaping marijuana around the minor child in the presence of her supervisor. This time we filed it because on August 31st, 2024, he had the minor child in a car seat. She was driving without a license, without a supervisor. That's why we filed this. Because of that, the court said that she would have the supervised parenting time we talked about earlier. And somehow, because she did 7 very supervised parenting time, now she gets unsupervised. She's being rewarded, in a sense, for violating the court orders, not once, but twice. I also don't see that somehow she understands that she's wrong about this. Opposing counsel in front of the court indicated that the problem is that my client overreacted, that he traumatized the child when she's driving without a license, without a child seat, and somehow she's going to be rewarded, and now she's going to have unsupervised parenting time. I don't think she should have something better than what she had prior to this, because she's violated court orders not once but twice in a very egregious manner. And I think that if we want to go back to the parenting time we had before, that's fine. I would prefer that my client be the supervisor because her mother has been a poor supervisor on 2 occasions. The court can continue what we have now for a while, but I know eventually we're going to be doing something else. I would rather than whatever parenting time there is that my client be the supervisor.
Mr. Ferguson, if you're going to put words in my mouth, make sure they're at least accurate. What I said in front of the referee, Your Honor, was that Ms. DeMille absolutely accepts the wrongs that brought her here back in October 2nd. She knows she shouldn't be driving without a license. She accepted that. But also the fact that the plaintiff did traumatize a child on that date. According to the video that I saw, the child was crying when the plaintiff father stopped her. But regardless, she has accepted her wrongs. She knows what she did was wrong, and she's willing to abide by all court orders 100% going forward. Every day she tells me that she cries because of the situation she finds herself in, that she put herself in, and she knows that she put herself in, Judge. She accepts that, and she has done what is required to go forward, and she's been doing excellent, Judge. She has been in AA since January and has been sober since that from alcohol, Judge. I know that the plaintiff keeps on and loves to harp on that she was arrested all these times, and the last time she was in trouble for the alcohol offenses was in August of 23. But we certainly accept the alcohol provision, Judge, and I think it is in the child's best interest to start seeing his mom unsupervised. It's unnecessary at this point. We certainly accept that they're wrong, that she realizes that she can't drive even 2 blocks down the road. She accepts that was wrong and knows that it's in the child's best interest that she doesn't do that, Judge. But at this point, it's in the child's best interest for Ms. DeMille to have unsupervised parenting time with her child for 5 hours every other Saturday.
Well, Mr. Fleming, the credibility of your client is certainly is brought into question. It's like, well, I can do what I want, but as long as I don't get caught. So obviously, the court questions her credibility when she says, "Well, I'm not going to do this again." The judge gets caught. With whom does Miss DeMille currently reside?
She does stay with her mom, Judge, and it wasn't a matter of not getting caught or anything like that. She just had a new child. When was your child born?
August 17th.
August 17th, Judge, and the mom was staying home with the new child. She promised the child here, Everett, ice cream, and she wanted to get the child ice cream. She knows that it's absolutely wrong. She doesn't do it just to flaunt the court's orders by any stretch of the imagination, Judge. But of course, it's up to Your Honor, but I think she was just trying to make the child happy, and she realized that she was wrong.
All y'all Americans need to learn to walk places, okay? People looked at me like I was fucking insane when I was walking in Texas and Florida. They're like, "You're gonna walk there?" I'm like, "Yeah. I'm planning on walking there. If the fucking ice cream was close enough, 2 blocks, walk. Walk. Nice enough to get ice cream, nice enough to walk, huh? I don't know. It would never occur to me to drive without a license. I mean, it just wouldn't occur to me. But again, I guess my brain just works different. I'd just be like, figure it out.
Well, again, it's obviously not an emergency. Mom can go to the store and get ice cream and bring it back to the house rather than put the child in that situation. Is Mr. Mill still on probation?
Yeah,
Yes,
she
I-
is
sorry.
on probation still through Lucas County.
And when does that probationary term expire?
But technically, I don't think
Trick question, William. I'm always high. So the answer is yes. I would think about it once high. Honestly, I don't understand when people like pretend like getting stoned like changes your entire perception. It's not like getting drunk. It's just not. I mean, for the first couple times for sure, but it's just not the same. Anyways, the reality here is that the friend of the court has already recommended that she get this time unsupervised. What will the judge do?
3 years, so, but. Okay.
2 years from when, Mr. Fleming?
6, so it should be 2006 or 7. Okay, when did it start?
I believe
23, 24, 25, 26,
It'd be
either 26 or-
2026, August of 2026, Judge.
Or actually, hold on, it didn't get put, no, it'd probably be the following, because the accident happened in August, but because of me being hospitalized and whatever, it didn't actually happen set until February.
So probably February 2027.
Yeah, probably around then.
February 2027, Judge.
I had to think about it, I'm sorry, Your Honor.
And how often does Mr. Mill attend A meetings? How many times per week?
Weekly, at least 3.
Has Mr. Mill exercised all the parenting time to which she was entitled to with Family County Shelter Services, or did she miss any sessions?
She has exercised all sessions, Judge.
Right. Who will be transporting, if the court adopts this recommendation, who will be transporting the minor child to the defendant mother's home? Is it the maternal grandmother?
Yes, Judge. Mr. Mills, wow.
Okay. Is Mr. Mill required to submit to regular drug screens as part of her probation?
Breathalyzers at random or anything at their discretion, I believe.
Okay. Court talking about drug screens. Did she just use marijuana? Is that prohibited under terms of probation? Does she submit to random drug screens?
No.
Okay. What about the holidays? Is the front of the court holiday schedule been adopted in this case? Is there any discussion about the upcoming Christmas holiday?
There was not any discussion, Judge, but that is an excellent point. I mean, I'm sure everyone would love to see his mom on Christmas.
Yeah, I would love to see them.
Birthday.
Christmas, of course, this year is on a Thursday, but that was not raised during your discussions this morning. obviously the court would encourage it so that the child can spend some time over the Christmas holiday. The child's what, 6 years old? As far as the child's concerned, Christmas lasts a whole week. In any event,
I feel like Christmas lasted like a month when I was a kid. How much sleep did I get last night? I never really know until my Fitbit tells me. Did pretty good though. 7 hours, 9 minutes. But I was up, at 5:30. I would have got more, but I had to get up at 5:30.
the court's going to give mother another opportunity to prove herself, and the court will adopt this recommendation. It's it's limited, 5 hours every other Saturday, no overnights. And the mother must provide proof that she's attending A meetings. Why can't that be provided weekly rather than every 30 days? Recommendation says she'll provide it every 30 days. So if the court adopts the language of this, Mr. Ferguson will not receive a proof of A meetings until early January. So presumably Ms. DeMille is getting a verification sheet completed every time she goes to A meeting, correct, Mr. Fleming?
That's correct, Judge.
Okay, any reason why she can't email that or fax it to Mr. Ferguson or Mr. DeFalco weekly?
I see no issue with that.
I should be able to.
Okay, so she can provide, do it on Friday or Saturday. I'm not sure what day she attends. So the question adopts recommendation with one, the modification, Mr. Walker, if you can modify this, the mother should provide proof every 7 days. So weekly. So the court suggests she provide that proof Friday or Saturday morning. Friday, the day before, the weekend, the Saturdays, alternating Saturdays that the court is awarding, so that Mr. Falco has documentation that mom is attending 3 A meetings that preceding week.
Thank you.
So I don't know if we need to be more specific that mother should provide this weekly prior to a mother's just weekly. The intent of the court is that it be provided on the Friday or Saturday preceding mom's alternating weekend parenting time. So Mr. Walker, if you have, we want to word that. I think of course made it clear how that's done. We just put that to be done. It should be provided weekly. And that should be sufficient with the court's clarification that the court would hope that Mr. Falco would receive that on the Friday prior to mother's alternating Saturday parenting time. And if there's any issues, Ms. DeMille, you need to, if there's any issues, you're going to go back to supervised parenting time at that agency. So it's you need to strictly comply and adhere to this.
Yes, Your Honor.
All right. Is there anything further than this morning, Mr. Ferguson or Mr. Fleming?
I have nothing else.
No,
Okay.
Judge.
All right. All right. That will conclude this matter. Thank you, Mr. Walker. The court will adopt the revised recommendation. Copy will be sent out to council. See everyone in February then.
Thank you.
Thank you,
Questions
Judge.
about?
Thank you.
Have a good day.
Good Christmas.
February 5th at 10. Christmas.
Jackson, I think we can just change the words every 3 days to just a weekly.
Yeah, that's what I did, Your Honor. I'm uploading it right now on Donbase.
Okay. Thank you. Good morning, Ms. Brower.
Good morning, Judge. I met with the parties on the 9:30. They are both on public assistance on the same case at DHS. And typically we would not have a child support order if they are residing together on the same case.
Hey, it just bothers me. It seems like why should the taxpayers support their children? But I have no authority in that regard.
I can run child support, but with them living in the same house on the same case at DHS, they're both on public assistance.
So I guess they need to put in their before the judge, just reserve the child support. Is that what we should do? Because it does not address it.
Yeah, it could be reserved. What would happen is if one of the parents leaves the home with the children, say if dad was out of the home, DHS would send a referral to our office to do a child support recommendation anyway. So we would have a child support order once they separate.
But it just rubs the court the wrong way. They can live together until the children are 18 and the taxpayers are going to support those children.
Understood.
Any other suggestions?
I don't, unfortunately.
Okay. But that's your understanding is that the court cannot order that when they're both under the same case until they separate?
I believe the court, has the authority to do anything. I can run the child support, but with them living in the household, it's
Right.
they're reimbursing their own public assistance.
They can reimburse the state of Michigan rather than go to one parent. Maybe run that by Stephanie, see if she has any if that's possible, just to reimburse the state of Michigan.
She stepped out of the office.
Okay,
I did speak with Mr. McKee. His position is to reserve child support until they live separately. I believe it is their intent to separate at some point
okay.
when they're
How do we
financially
know-
able to do so.
Okay, yeah, that's what I'll do, but how do we know when they separate? If they never notified the front of the court?
When they separate, they'll notify DHS.
What if they don't?
And
What if they
DHS
don't
will
notify
send a
anyone?
referral. Every 6 months, they have to renew their case at
Gotcha.
DHS. And so
Gotcha.
they'll be
Okay.
notified that one of the parents is out of the household.
Okay, yep, thanks for that
Okay.
explanation. Okay.
I'll
Thank
bring
you.
them
just
out.
reserve it then. Thank
Okay.
you.
Living together on public assistance, getting a divorce. That's the way we spend our fucking Tuesday morning, of course. Seriously. That's literally what they're doing.
Young couple. Good job. Seem like a young couple. Okay.
On the matter of Whitney Betts versus John Betts.
For the record, this matter is before the court on the plaintiff's motion to enter a consent judgment of divorce. This hearing is being conducted via Zoom. Are you Whitney Betts?
Yes.
And sir, you are John Betts?
Yes.
Okay, good morning. Both parties are present and this actually seated next to each other, which is wonderful. You've talked with front of the court regarding child support, and you're both on the same public assistance grant. So the court will reserve child support at this time. However, there's an issue of filing fee. You both appear to be young. I'm not sure if you're disabled, unable to work, but there is a filing fee that was previously waived, and the court wants to address that in its judgment of divorce. And I'll give you as much time to pay that. It's a $255 filing fee. And the court wants one of you to pay that, the other person can reimburse it, and I'll give you as much time as you need to pay that $255 to the Monroe County Clerk. So do either of you have any employment income?
Yes, we both are employed.
You're both employed?
Yes.
I'm sorry. I didn't hear you very well, Ms. Betts. Can you speak up a little bit?
Yes, we're both employed.
Okay. Yeah, it's sort of an echo, but in any event, in the judgment divorce, I'm going to put one of you needs to pay it. The other person, you're both living together, correct? You tend to live together. So do we want to put in there that Whitney will pay it or John will pay it?
Which one?
Me.
Oh, okay.
I will.
John, that's $255. How much time do you need in which to pay that?
Can it be cash or credit card?
You got to, maybe you need to speak closer to your device. We're not picking you up very, very clearly.
Okay. Do you guys take any forms of payment?
No, it's gotta be one lump sum. They will not take installment payments. They'll take a credit card, but they're gonna charge you a fee if you use a credit card over the phone, or you come in with cash and pay it. You'll save yourself a few dollars by paying in cash rather than a credit card. They will not take personal checks. They will not take installment payments.
3 months.
Okay?
The judge is he's so grumpy today. Everything's going the way he wants it to go, and it's still not good enough. Just wait.
Okay, it's 3 months, so you can pay that by the last day of February is February 28th.
Yes, Your Honor.
Okay, and if you can't pay, you need to contact the court and ask for additional time, because when you blow it off, that's when bench warrants issue for your arrest. We don't want that to happen.
I understand.
Now, again, obviously, Ms. Betts can help you with that. She can give you some money. Why does it take 3 months for the court to monitor this for 3 months? Can you do it at the end of January?
I was thinking more of holidays, and then 3 of the kids' birthdays are in December.
Okay. Okay, but that give you you're both employed and you receive public assistance. Even though there's Christmas and birthdays, you can't do that by January 31st, 2 months.
Yeah.
Okay.
Yeah, I can do 2 months. That's fine.
So January 31st is the last day of January. If you need more time, call the court, but I want you to make good faith effort to pay that $255. I'm going to write in this judgment, they should pay $255 on or before January 31st, 2025. Mr. Bestis, contact the court if in fact you can't pay the full amount by then, but put some money aside, or if you got a credit card, you can pay it over the phone on the credit card. That'll
Okay,
give you more time to pay the credit card. You just need to give the county clerk, because you both know where that's located, second floor of the courthouse. Okay. The other matter the court needs to address is, since there are minor children, there's a statutory 6-month waiting period to make sure there's no chance of reconciliation. The 6 months begins running the date you file this petition for divorce. That was filed on October 3rd. The 6 months expires April 3rd. But this court does have the authority to waive that and end the judgment of divorce today if you both agree, you both believe it would be the best interest of the children to finalize things sooner than later. Finalizing, getting the divorce today rather than April 3rd. So, Ms. Betts, you asking the court to waive the statutory waiting period and enter the judgment of divorce today rather than wait until April?
Yes, please.
I believe that would be the best of your children to finalize things sooner than later.
Yes.
Same question to you, Mr. Betts. You asking the court to waive the statutory 6-month waiting period and enter the judgment of divorce today?
Yes, Your Honor.
To believe that to be in the best of your children?
Yes, Your Honor.
Right, the court will do so. Can you both raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. All right, we'll hear from you first, Miss Whitney. Can you please state your name and current mailing address for the record?
Whitney Nicole Betts, 40.
Thank you. Is it true, Miss Betts, you filed a petition for divorce on October 3rd, 2024?
Yes.
Is it further true that on the date you filed that petition, you've been a resident of the County of Monroe at least 10 days and the state of Michigan at least 6 months?
Yes.
Is it further true that there's been a breakdown of your marriage relationship with John Betts to the extent that the objects of matrimony have been destroyed, there's no chance of reconciliation?
Yes.
Is it true that there was 2 children born of the marriage who are still minors, Jonathan and Vivian?
Yes.
Were there any other children born or adopted during your marriage who are still minors?
That are still minors? No.
Are you currently pregnant?
No.
And you signed your name to this consent judgment approving the terms and conditions contained therein, is that correct?
Yes.
All right. Mr. Betts, can you please state your name and address for the record?
John Dwayne Betts.
Your device, your address?
Sure. It's 40.
Amazing, amazing, amazing. I unmuted him first, but thank you so much, Miss Donna Orlando Chiquita. How's the weather down in Florida? I hope you guys are staying warm. I know it's cold all over the United States lately, so please stay warm. Hi, Miss Donna. Weather's gorgeous. Love it. Jealous. It's cold as fuck here. We have to plow through the rest of this because the other court that I'm recording for us for later this week that is juicy as F. I'm going to say that. Juicy as F. We can't miss. They're coming back from lunch. I'm going to have to set up some contraption to do it and pray that they don't switch streams midstream. Because I'm leaving the house in a little bit. I'm just going to start a recording and hope that I get it all. Anyways, thank you again, Miss Donna. Welcome new members. And let's continue on with this, what seems to be very amicable divorce. By the way, they live at the same address. They live in the same house.
Thank you. That was much better. Mr. Best, did you hear the testimony this morning of your wife, Whitney?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes, Your Honor.
And you also signed your name to this proposed judgment approving the terms and conditions.
Sometimes the names we see when people gift memberships are so from the long lost life. Anyways, thank you, Mikey. That's so sweet of you. Look at you and Donna both gifting memberships in this December morning. Both just trying to stretch it out, and I love it. Merry Christmas to you too. Is it Christmas already? I tend to celebrate my daughter's birthday before we celebrate Christmas. But I get it. They have a decor on their vampire mirror. And thank you again, Mikey and Donna. Do I have snow where I live? No, and hopefully we won't. There shall be no snow here. That's the whole point of why we live here. No snow.
Contained therein, is that correct?
Yes, Your Honor.
Okay, the court's going to go through this with both of you. You both agreed that you will share joint legal as well as joint physical custody of your 2 minor children, which is wonderful. The court applauds you for that. Parenting time, once you separate, shall be by agreement. If a disagreement arises, you can always petition the court for a specific parenting time schedule. But hopefully you can work that through together. Be on the same page for the benefit of your children. With respect to child support, the court will reserve the child support. I'm going to write the word reserved. I'll put my initials next to that. So if you do separate, the front of the court will petition for a child support order to enter so that the state of Michigan can be reimbursed for the state of Michigan for the public assistance being provided. Spousal support, known as alimony, that you've agreed that's not awarded and it's forever barred.
Yes.
You'll attach to your judgment a personal property and debt addendum.
Flusha, hi. And I think you missed the window for Mikey because he already sent out the Christmas cards, if I'm not mistaken. And how many did he send? So many. So many Christmas cards. I'm still mad at Canada Post, who's on strike, thwarting any Christmas cards being sent to me. But the very, very minute opening of time within which to ask for a Christmas card, I guess. Anyways, Judge is so mad at this couple already because they're both on public assistance and living together. It's already just put a bee in his bonnet.
Which will, and your debts are divided according to that addendum. Namely, the plaintiff Whitney is awarded $250 in a savings account at the Monroe County Community Credit Union, as well as $250 in a checking account at the credit union. Defendant John is awarded the same. So you're basically going to close out those two accounts. Each of you will get half. Is that correct?
Yes.
It's probably better to separate things so we don't have problems in the future. So any joint accounts, separate these, withdraw them, put them in your own, in a new account in your own name. There's credit card debt. So the plaintiff Whitney shall pay, looks like you're splitting it down the middle. Whitney shall pay an Amazon credit card in the amount of $500. John will pay an Amazon credit card in the amount of $500 as well. So it's approximate. In addition, there is a credit card to the Monroe County Community Credit Union. Each of you will pay Whitney will pay $1,000 to the credit union credit card. John will pay $2,000 to a care credit. The Lowe's card has been paid off, correct?
Yes, we're working on that.
So it shows Lowe's is zeroed out. That takes care of all the debt. If you have any debt in your own name, when you'll pay that, and your debt in John's own name, he'll pay that. These are the joint debts, the Amazon, the credit union, and care credit.
Is that common to have an Amazon credit card? Sometimes I feel like such a loser. Can you hear that? What are they doing? I think they're building a house.
With respect to real estate, the two of you own the real estate known as 47 East Lorraine Street. That property is awarded to both of you. You both agreed that that home will be ultimately sold, and you'll share equally the net sale proceeds. Is that correct?
Yes.
When do you plan on putting that in the market in the spring?
Probably in the next few months, we're hoping.
Okay. So two of you own that.
Yes.
Finally, with respect to, there's also an income tax addendum that the plaintiff, Nicole Whitney, is awarded the right to claim the two children as a dependent for tax purposes for 2024 and all future tax years.
Yes, yes.
With respect to personal property in the home, once you separate, can you agree to divide that, pots and pans and things of that nature?
Yes.
Yes.
Okay. Vehicles, you each keep your own vehicle and pay any debt associated therewith. Again, the real property is awarded to, according to the attached real property addendum, whether it's going to be liquidated and split equally. Each will be entitled to their own retirement plans, whether it's an IRA, 401k, or pension. And Miss Betts, Miss Winnie, you're going to keep the name Betts, correct? You're not asking for a change of name?
Yes.
I'm sorry?
Yes.
All right, thank you. All right, Miss Winnie, do you have any questions for the court?
No.
John, do you have any questions for the court?
No, Your Honor.
Well, and Mr. Betts, just make a note in your calendar to pay at 2:55 on or before January 31st to the Monroe County Clerk. And based upon their testimony that's been provided this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the opposite matrimony had been destroyed and there appears to be no reasonable chance of reconciliation. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved and judgment shall enter granting a divorce from bonds matrimony. Court will sign the judgment, a copy mailed out to both of you. That will conclude this hearing. Good luck to both of you. Have a good holiday with the kids. It's one thing you can co-parent your children. They will do well if you're both on the same page. I applaud you for that. In any event, that will conclude this hearing. You can both zoom out. Have a good rest of the day.
Oh, thank you so much.
Have a wonderful day.
Thank you.
They look so happy to be divorced. That was fucking hilarious to me. They dissolved their marriage and then were divorced. I don't know actual sign language, but if I was making up sign language, that's the sign language that I would make up for that. They seemed weirdly happy. I don't know what's going on. They didn't also look to me old enough to have an aged out child, but evidently they do. So kudos to them and their skincare regime that I'm sure they share. Anyways, they totally dressed alike. They live together, take divorce pictures. They're sharing the debt, they're sharing the money, they're sharing every bit of it. Love it. Love it. What a lovely note to end on for today. Because that's what we are ending on for today. Because I got to get back to it. I have a nasty divorce for us. Oh, it's nasty. It's going to be so good. Buckle up this weekend and this basically Thursday, Friday, Saturday is going to be busy for court for us with stuff that I am getting now. So it is December, so remember that next month is January. Crazy. I'm floored. Thank you, Credence and Mikey, and thank you so much, Miss Orlando Chiquita. I really appreciate each and every one of you. Yeah, there will not be a show tonight for me, but I'm sure that Creed will be gambling and maybe there'll be a live chase that breaks out that will all be gifted. I don't know. We can hope, right? Anyways, remember that I love you and I'm proud of you. And I will see you in the next video. Okay? Bye.
Ways down and ready to ride.